During a recent video on my main channel, I talked about the arbitration issues with Live Nation and Ticketmaster on the Ninth Circuit Court of Appeals. Held that to be unconscionable to force that on consumers because of the way that the arbitration itself was set up and appeared to be slanted against consumers. And I mentioned that I've encountered that before in my practice of lemon law, which I've been doing now for 33 years. Lemon law, it's all I deal with in Michigan. MCL 257-1401 et sec. But 257-1405, which is part of the lemon law, talks about the fact that manufacturers can, if they want to, set up a process whereby they can have an arbitration requirement so long as the arbitration is fair and meets certain guidelines. So, this is important to follow. 1405 says informal dispute settlement procedure. If a manufacturer has established or participates in an informal dispute settlement procedure, the provisions of this act shall not apply to any consumer who has not first resorted to the procedure if the procedure does all of the following. One, it's got to comply with the Magnuson-Moss Warranty Act because in there it talks about informal dispute settlement procedures. Two, it's got to require the manufacturer to be bound by any decision reached. So in other words, the manufacturer is stuck with that decision. Three, provides that the consumer is not obligated to accept the decision and may pursue the remedies provided for under this act. So, and there's another thing about requiring the manufacturer to initiate the process necessary to implement any final settlement, not more than 30 days after the settlement has been reached. But the key here is that the manufacturers under the lemon law are specifically told if you want to, you can create an arbitration process that's got to meet the Mag-Moss guidelines and it's binding on you, but not the consumers. And if you create that process, you can then force consumers to go through it. They're not bound by it, but they have to go through it. And guess what? A lot of consumers would go through that, and if you awarded them a full buyback, would take it. Interestingly, the manufacturers almost never did this. Once or twice, we'd hear a little bit of squawking about how they're going to try to do it, and they didn't do it. And then in 2003, something very strange happened. I understand this is 20 years ago. Okay? 2003. Friends of mine who do lemon law said, Steve, we got the craziest case. They had a client who bought a vehicle with an employee discount. Okay, so they still bought the car, brand new, but by using an employee discount, they got a great deal on it. And they said the car was defective, and they couldn't get it fixed, and so they wanted to file a lawsuit. They filed a lawsuit, and the manufacturer went into court and said, Your Honor, in the employee discount papers is a requirement to arbitrate the claim. They have to arbitrate the claim, and it's in the papers. It's not in the warranty booklet or anything. And so it's only for employees, but to get the discount, you have to sign this waiver saying, I promise I will not sue the manufacturer. I will arbitrate my claim through this arbitration process the manufacturer set up. And my friend said, we're fighting this in court. We won it at the trial court level, but they took it up on appeal, and on appeal, they lost. The Michigan Court of Appeals said specifically that, no, they can force you to arbitrate. Now, here's the thing. I went and pulled the language to make sure I had this right, because it's been a few years since I've actually looked at the actual opinion. But the key provision of the Purchase Program Agreement, which is the document regarding the employee purchase, says, in addition, if I am the purchaser, I understand that in consideration of the discount I receive on the purchase, I will not be able to bring a lawsuit for any dispute involving repairs made to that vehicle under GM's limited warranty or regarding the extent to which such warranty coverage is provided on that vehicle. Instead, I agree to address such disputes through the GM dispute resolution process, which includes a mandatory arbitration that is binding on both GM and me. So you, in essence, are waiving your right to the arbitration by signing this agreement and getting the discount when you buy the car. Just so you know, there's also a section of the lemon law that says you cannot waive these rights. These rights absolutely cannot be waived. Otherwise, every single manufacturer would tell the sellers that sell their cars to put in the purchase agreement, by the way, I waive my lemon law rights. You want to buy a car? Waive your rights. So you can't be asked to do that. So GM went to the Court of Appeals and said, client customer signed this document and agreed to binding arbitration. And my friends at the other law firm said, well, number one, you can't do that because it says here that if you want to, you can only have this informal dispute settlement procedure, which is binding for the manufacturer but not the consumer. And the State Court of Appeals in Michigan said, well, you got a problem. Because there's a law called the FAA, which I mentioned in the other video, the Federal Arbitration Act. The Federal Arbitration Act said that if somebody wants to arbitrate a claim and the parties agree to it and it's legal, courts will enforce it because the courts want to encourage people to arbitrate claims rather than litigate them in court. The problem, of course, with this is the FAA was passed a long time ago. The Lemon Law was passed many years after the FAA. And they brought this up on appeal. They said, by the way, these two laws, the Magnuson-Moss Warranty Act and the Lemon Law, were drafted after the FAA existed. So the drafters are presumed to have knowledge of existing law. So the Court of Appeals says, no, the FAA preempts the Lemon Law and it preempts the Magnuson-Moss Warranty Act. But if the Magnuson-Moss Warranty Act talks about arbitration and the Lemon Law talks about arbitration, and the FAA is already on the books, they're supposed to actually assume that the drafters of those two laws knew the earlier law existed and were writing this instead or on top of that. And the Court of Appeals in Michigan just said, no. If you sign this agreement, they can hold you to binding arbitration. Notwithstanding the fact that Lemon Law says you can't waive your rights, and if there is an arbitration, it can't be binding on you. I know it's going to be a little confusing, but we're talking about three different statutes here. The FAA, which is the Federal Arbitration Act, the Magnuson-Moss Warranty Act, and Michigan's Lemon Law, for the purposes of our discussion. And I mentioned that these things actually were passed at different times. That's important because the FAA was passed in 1925. The Magnuson-Moss Warranty Act was passed in 1975. And the Lemon Law was passed in 1986. Michigan's Lemon Law was passed in 1986. So the FAA had been on the books for 50 years when Congress passed the Magnuson-Moss Warranty Act. The Magnuson-Moss Warranty Act has built into it a whole section on whether or not manufacturers can force consumers to go through arbitration to enforce their warranty claims. Okay? Whole section on that in the Magnuson-Moss Warranty Act. That's 50 years after the FAA was passed. Then, when the Lemon Law was passed, 11 years after that, the Michigan legislature said, okay, we're going to, in essence, adopt the Magnuson-Moss Warranty Act rules on arbitration and to say that you can force consumers into arbitration so long as it meets certain guidelines, particularly those laid out by the Magnuson-Moss Warranty Act. So when the case came along that I'm talking about right now in 2003, which of course is 17 years after, and again, I did the math, even though I'm a busy man. I did the math, even though I'm a busy man. When they passed the Lemon Law, okay, the Mag-Moss Warranty Act had been on the books for a period of time. And that, of course, was well after the FAA was passed. The reason this is important is that you obviously can't pass a law that just contradicts a prior law, and especially like a state law can't just be passed to override a federal statute. You can't just do that. It's not how the laws work. However, the reason I pointed out earlier that the legislators are presumed to know other laws exist is that when a court is asked to examine a law, one of the things that they look at is, okay, does this law make sense? And you might look at the situation with the Lemon Law and go, well, Steve, on the one hand, it seems to disfavor arbitration, and the FAA seems to favor arbitration, so that means that section of the law should just be kicked out. Unless you realize that there is a way that courts are supposed to look at statutes, and one thing they're supposed to look at is they're supposed to look at the statute and assume that there's a way that it works. So if there's several different ways to interpret a statute, and one of them is that it conflicts with a prior law, You go, okay, but is there a way it doesn't conflict with the prior law? And there, of course, the answer would be yes, yes. And so if they looked at it and said, okay, let's presume that the Michigan legislators in 86 knew the FAA existed, and the federal legislators in 75 knew that it existed, and both those sets of legislators passed a law that talks about arbitration, is there a way to make it to where these laws all work with each other as opposed to conflict with each other? And yes, there is. And so if you go and look at summaries of the FAA, Federal Arbitration Act, you'll find that it's encouraging arbitration, but it does not override state laws that govern the procedures of arbitration, and don't necessarily talk about how those laws are unless they actually completely explicitly say there's no, you're not allowed to have arbitration. But here, the Lemon Law and the Mag-Moss both say, yes, you can have arbitration, but to protect consumers, it's got to contain these things. And so when the Court of Appeals in Michigan said, oh, the FAA just overrules this, they're actually saying, in essence, that the drafters of the Mag-Moss Warning Act and the drafters of the Lemon Law missed the fact that there's a statute that made what they were doing irrelevant. And courts aren't supposed to do it that way. They're supposed to say, is there a way that this law makes sense? And if so, read it that way. So I've talked before about the rules of statutory construction, how you construe a statute, and that's one of them. That's one of them. So courts are supposed to look at the law and presume that the drafters of the laws understand the law, and they know about existing law, and therefore the law should be read in a way that is in congruence with all the laws working together, as opposed to, oh, this one just is wrong, we're going to strike it. So that's what I'm talking about when I talk about the time frames. The FAA passed in 1925, Mag-Moss 50 years later, and then the Lemon Law 11 years after that. So there you go. But don't forget, that's the same Court of Appeals in Michigan that said that if you remove the lug nuts from a car, you have performed a tire rotation. Because the tire rotation would start with removing lug nuts, then rotating the tires, and then reinstalling the lug nuts. And they said a dictionary definition of the word perform is to do something. And they did something. Something like that. I'm not getting the exact words right, but that's the concept. And, of course, elsewhere in that same statute, it said that you must certify the work has been completed. Completed. And they didn't address that. How completed is the work if we started it and never finished it? Doesn't matter, they performed it. So I know that my friends tried to get the Michigan Supreme Court to hear this case, and they declined, meaning they're like, no, it's good law. It's good law. So the weird part about this is that at the moment it happened, our first thought was, well, they've said that manufacturers can put the arbitration agreement into the discount papers when you buy a vehicle using an employee discount. And we never quite understood why they did it, because they did not start forcing people, as far as I know, to do this, because I never encountered it again. But it's almost like they did it just to prove a point. They got it done, and then they just kind of, if we need to, we can do that in the future. But it's crazy because people often complain to me and they say, Steve, lawyers make things so confusing. It's not the lawyers. It's the people who draft the laws. And people go, but Steve, most legislators are lawyers. There are a lot of legislators who are lawyers, but I don't think that's going to make them draft the laws any better or any worse, because here we've got a situation where they passed a law in Michigan, the Lemon Law, not so long ago in the grand scheme of things. And they addressed everything they thought they needed to address. And it references another federal statute, which was about, I think, 10 years old at that time, 15 years old at that time. And they mentioned the other statute in there. And then, when it gets litigated, the Court of Appeals goes, well, you guys all kind of missed the fact that there's this law that got passed decades earlier that overrides these two laws. And a Court of Appeals making that ruling? What? So, this arbitration thing pops up all over the place. And we've talked about it before. And we talked about it with respect to, people buying a service and they say, oh, by the way, it was buried in the language on your screen that you approved. Or if you buy a phone from one of the major phone carriers and the contract they have you sign is allegedly on a screen, and it's the same screen that processes your credit card. So you can read it about 20 words at a time if you scrolled through it. And in reality, most people walk up and just hit accept. And who knows what's in there besides the arbitration agreement. You're probably swearing, that you will let them have your firstborn and any real estate you might come into the next 20 years. Who knows? It's in there. But I was just reminded of this story. And that's the kind of stuff that you get. And, Court of Appeals in Michigan, like I said, okay, you've performed a tire rotation when you removed the lug nuts because you began the work. And in that case, they did put the lug nuts back on. They just didn't tighten them. And by the way, they admitted that. I've had people go, Steve, maybe they did tighten them. No. The argument was, even if they didn't tighten them, the plaintiff couldn't win that case. So you get these crazy results. So again, the lemon law in Michigan says you cannot waive your rights under the lemon law. And the only way you can be forced to arbitrate is if the arbitration process is not binding on you, the consumer. Along comes a manufacturer and says, you want this discount, sign this and promise to arbitrate with us, which sounds like you're waiving your rights. In an arbitration that's binding on you, which violates the lemon law. And a court of appeals said, sounds good to us. I only laugh because it's absurd. Questions or comments, put them below. Let's talk to you later. Bye-bye.